One of the Pacific Legal Foundation's primary missions is to challenge regulations that exceed agencies' constitutional and statutory limits, especially when that overreach violates individual rights. To that end, Pacific Legal Foundation is frequently involved with protecting private property rights against agency abuse under the Clean Water Act. Today, I'm going to provide a general background on the Clean Water Act and how we got to where we are today with the Supreme Court case, U.S. Army Corps of Engineers versus Hawks, that PLF is arguing later this month. Most of what I cover is in an issue brief I co-wrote with my PLF colleague, Damian Schiff, who won Sackett versus EPA, one of the Supreme Court cases I'm going to discuss. So let me begin with a description of the Clean Water Act. Congress passed the Clean Water Act in 1972 to protect the quality and integrity of our nation's navigable waters. The preamble to the act acknowledges the statute's scope is limited, declaring that it's Congress's policy to recognize, preserve, and protect the primary responsibilities of the states to prevent, reduce, and eliminate pollution and use land and water resources. The Act is jointly administered by the Environmental Protection Agency, EPA, and the U.S. Army Corps of Engineers, known as the Corps. This is primarily done through a permitting mandate, and under this mandate, a property owner must first obtain a special permit before discharging any pollutant, which is not just a toxic chemical. It's defined so broadly to include such mundane materials as dirt and sand into navigable waters, which the Act unhelpfully defines as waters of the United States. Over the years, the EPA and Corps have extravagantly expanded the scope of the Clean Water Act, conveniently increasing the amount of land they have power over. As I mentioned, the Clean Water Act applies to navigable waters or waters of the United States. Consistent with the traditional definition of navigable waters, the Corps' original regulations defined waters of the United States as interstate waters that are capable of being navigated for use in commerce, in other words, navigable in fact, or traditional navigable waterways. For example, when I think of a navigable waterway, I think of something like the Mississippi River pictured on the left, where big boats can go through for commerce purposes. However, today the EPA and Corps are likely to consider any moist ground, like a lot of ground around here after the recent rain we've had, like the pictured on the right, to fall within the ambit of the Clean Water Act. So how did we get from regulating big rivers like the Mississippi to damp ground in your backyard? In some ways, it began with an environmentalist lawsuit in which a federal district court ruled that the original regulations limiting the Clean Water Act's scope to traditional navigable waterways was too narrow, and the court ordered the Corps to redo them. Rather than appeal that decision, the Corps decided to use that as an opportunity to pass substantially broader regulations. For example, they extended the Clean Water Act jurisdiction beyond waters that were actually navigable to include most small tributaries of those waters, as well as adjacent wetlands. Property owners challenged that regulation, including the adjacent wetlands, all the way to the Supreme Court in a case called United States versus Riverside Bayview Homes Incorporated. In that case, the Supreme Court affirmed that the Clean Water Act regulates at least some waters that wouldn't be considered navigable under the traditional definition of that term, including wetlands that were immediately adjacent to a navigable, in fact, water. Emboldened by their victory, the EPA and Corps proceeded to apply the Act even more broadly. For example, the Corps adopted a so-called migratory bird rule, whereby it asserted power to regulate any pockets of rainwater that provided a habitat for migratory birds. This rule was challenged all the way to the Supreme Court in the case Solid Waste Agency of North Cook County, also known as SWANC, versus U.S. Army Corps of Engineers. This case involved several abandoned sand and gravel pits that, when filled with rainwater on occasion, were the perfect puddles for certain migratory birds. Here, the property owners prevailed, with the Supreme Court rejecting the migratory bird rule and reminding the Corps that the key statutory phrase, navigable waters, actually means something. Isolated interstate waters that are only navigable for birds don't count. Rather than retreat from their overbroad interpretations of the Clean Water Act, the Corps and EPA adopted a so-called hydrological connection theory that further expanded their jurisdiction to cover all wetlands so long as a single drop of water could theoretically travel from those waters to a navigable, in fact, water. The Pacific Legal Foundation challenged that theory all the way to the Supreme Court in the case Rapanos versus United States. John Rapanos was a Michigan landowner who wanted to develop his cornfields. Because he backfilled those fields by basically just putting dirt in the cornfields, the federal government sued him and sought substantial civil and criminal penalties. The government's rationale was that Rapanos' occasionally saturated cornfields were wetlands and therefore covered by the Clean Water Act, because water could flow from them through a series of ditches and streams all the way to a navigable, in fact, waterway located miles and miles away. In a fractured decision, the Supreme Court vacated the judgment against Rapanos and rejected the government's broad theory of jurisdiction. The plurality of 4 justices adopted a 2-part standard, concluding that for tributaries, the Clean Water Act extends only to relatively permanent, standing, or continuously flowing bodies of water that are connected to a traditionally navigable waterway. And for wetlands, those must have a continuous surface connection with a traditionally navigable waterway. In other words, they have to be right. The water must be able to go from one directly to the other, or on the surface. Justice Kennedy provided the key vote in this case. While he agreed with the overall conclusion with the plurality, he disagreed with the reasoning. To him, the jurisdictional question depended on a concept of significant nexus. Under this theory, a wetland has a significant nexus and is subject to the Clean Water Act when it significantly affects the physical, chemical, and biological integrity of downstream navigable waters. And it's important to note that all 3 of those criteria must be present. Unsurprisingly, the agencies responded to their defeat in Rapanos by further expanding their authority. Last summer, the Corps and EPA issued a new Waters of the United States rule, also known as the WOTUS Rule, that, while purporting to merely conforming to the Rapanos decision, actually expands the jurisdiction even further. For example, it now covers dry creek beds, any water within 4,000 feet of a tributary, and even 100-year floodplains. The map on the screen shows one estimate of how much of California would be considered waters of the United States under the rule, but due to the complexities and ambiguities in the rule, no one really knows, and it's practically impossible to know what exactly is going to be covered. Essentially, this new rule allows agencies to control virtually every water and wetland in the country and micromanage the development of property located far from actual navigable waters. The Pacific Legal Foundation, along with dozens of states and private parties, filed suit challenging this rule. We argue that the rule's expansive power can't be reconciled with the text of the Clean Water Act or the Constitution. So far, 2 federal courts that have considered this challenge have stopped or enjoined the rule's application, concluding that PLF's clients and the other parties challenging the rule are likely to succeed on their claims. However, even if we prevail by invalidating the new Waters of the United States rule, the reality is it won't change federal control over individual landowners much in the short term. Knowing whether their property is subject to the Clean Water Act jurisdiction is extremely important for property owners. For one, the Act imposes severe civil and criminal penalties to those who violate the Act. Unfortunately, as Justice Alito recognized in a recent Supreme Court case, the reach of the Clean Water Act is notoriously unclear. For example, a recent official government report concluded that 3 core staff from the same district office were likely to make 3 different jurisdictional assessments over a particular property. Hence, obtaining independent judicial review of these jurisdictional calls issued in the form of compliance orders and jurisdictional determinations is crucial to protecting private property owners' rights. To that end, one of PLF's missions is to ensure that citizens have the right to a day in court whenever government agencies render final but disputed determinations that their property is regulated by the Clean Water Act. The first type of determination I'm going to cover are compliance orders. The EPA issues a compliance order whenever the agency believes the Clean Water Act has been violated. These orders command immediate actions or fines of $37,000, $500 per day, or $75,000 for willful violations. Despite these draconian fines, the EPA argued that compliance orders weren't final agency action that could be challenged in court. Pacific Legal Foundation challenged this view in Sackett versus EPA. This case involved an Idaho couple who received a compliance order shortly after beginning construction of their family home, pictured in the screen. They believed that the order was void because their property where they were building this home did not contain any wetlands subject to the Clean Water Act. And as you can see, it doesn't look like something you would typically associate as a wetland. Nevertheless, all the lower courts agreed with the EPA that the Sacketts couldn't challenge the compliance order in court because it wasn't final agency action. Fortunately, the Supreme Court disagreed and in a unanimous 9-0 decision held that compliance orders create significant legal and practical effects by commanding recipients to take immediate action under threat of substantial liability. In a separate concurrence, Justice Alito foreshadowed the issue raised in our present Supreme Court case by emphasizing how landowners are at the mercy of agency officials whenever the agency asserts jurisdiction over their land under the Clean Water Act. And that brings us to jurisdictional determinations. So what are these jurisdictional determinations? Because figuring out whether property is covered by the Clean Water Act is nearly impossible for a layperson, the Court issues jurisdictional determinations to inform landowners whether their property contains wetlands or other covered waters subject to Clean Water Act regulations. Just like compliance orders, these carry important legal and practical consequences. They have substantial real-world consequences on the legal rights and obligations of landowners. They put landowners on notice of the Court's position, which is important for determining whether the property owner acts in good faith. For example, a recent Ninth Circuit court case rebuked landowners for ignoring a court's determination. If the court determines they have jurisdiction, the owner is effectively required to pursue a special permit to use that property. This permitting process is extremely long and expensive. The average applicant for an individual core permit spends 788 days and over $200,000 to complete the process. So that brings us to the case presently before the Supreme Court, U.S. Army Corps of Engineers versus Hawks. In this case, PLF represents 3 family-owned and operated companies that harvest and process high-quality peat for golf greens and sports fields. The Hawks would like to expand their peat processing operation to include 150 adjoining acres. Since peat is formed in wetlands and can only be formed in wetlands, it is important for Hawks to have assurance that it is not subject to federal Clean Water Act regulations. Rather, it's only subject to all the Minnesota environmental laws and regulations. Following a years-long complex process, the Corps determined that the adjacent land was subject to the Clean Water Act because it had a significant nexus or impact on the Red River of the North that was located an incredible 120 miles away. Rather than allow a judge to consider the validity of this jurisdictional determination, the federal government claims that Hawks must first go through the expensive and time-consuming permitting process, even though the Corps warned during those 5 years that it was coming up with this determination that in the end it might not even issue a permit. This leaves Hawks with 3 options. 1, it could undergo that really long permitting process. 2, it could abandon the land with significant financial losses. Or 3, they could use the land without a permit, but then they'd be risking those severe fines and criminal penalties. On behalf of Hawks, we at PLF argue that those options are absurd. It's crazy for a company to pay hundreds of thousands of dollars for a permit that might not even be necessary. And this type of absurdity is not just limited to Hawks. There was a recent case that documented how one business spent 7 years and millions of dollars seeking a permit, only for the court to subsequently rule that the Corps never had jurisdiction over the property to begin with. Instead, we believe that Hawks should be able to go to court to challenge the Corps' jurisdictional determination. The 8th Circuit agreed with us that the issuance of a jurisdictional determination is final agency action subject to judicial review. The Corps appealed, and the case is now about to be argued before the Supreme Court. As Ilya mentioned in the introduction, we are very fortunate to have strong amicus support. While no one filed in support of the government, we had over 60 entities, including 29 states and over 30 organizations, file briefs in support of Hawks. I believe next panelist is going to discuss Cato's amicus brief that we're very thankful of, that focuses on the argument that courts should focus on the text of the Administrative Procedure Act, not judge-made common law when determining whether something is final agency action subject to judicial review. And since I'm running short of time, I'll just mention one other amicus brief that we had from the Center for Constitutional Jurisprudence from the Claremont Institute. And that brief argued that prohibiting judicial review of these jurisdictional determination violates the Constitution's separation of powers by allowing the Corps to have legislative, executive, and judicial power all at the same time over the Clean Water Act.